Oh, God, here we go again, guys. Oh, my goodness. Good morning, everyone. To all you gluttons for punishment out there, thank you so much for joining us. It is WGL AM, and I am joined by my two wonderful co-hosts. Good morning, Miss Hannah Hill.
Good morning, Bill.
How are you?
I'm pretty chipper, but that's an unfair advantage being on the East Coast. So
Yes, dude. Good
sorry about
morning,
that.
Kostas Morris. How are
Good
you?
morning. Good morning. I mean,
Other
I'm
than
not
Padres
wonderful
kicking my
because
Mariners' ass this weekend, how is everything else going for you?
that's true. That's true. I mean, it's the best era of Padres baseball ever.
Yeah,
Unfortunately,
playing
the
well.
Dodgers have also been incredible in this
You're
same
spending way
era.
too much money on Manny Machado, though. That dude is
Yeah,
not producing, and you're dumping a ton of cash in that.
that's true. That's true.
Hey, one of the things I haven't been able to do, and I want to remind everybody here that Kostas comes to us from the good folks over at the Second Amendment Foundation, and Hannah comes to us from the good folks over at the National Association for Gun Rights. And there are links for both of those fantastic organizations down in the description box for every one of the WGLAMs. And listen, I want to commend both of you and your organizations for putting together an amazing partnership on a couple of amicus briefs that you guys did on a case that we're going to be talking about today. So kudos to both of your organizations. For those of
Yeah.
you who've been through this before, here we go. Justice, I tried to find the one that you'd done out there. It was, but here's a new one.
Someone else made it. I just reposted.
Yeah, there we go. Here we go. It is Groundhog's Day again. We had a conference on May 14th, which was technically Thursday. This is our usual suspects, the 5 cases that we've been tracking for, months now. These are the number of conferences that we've had, give or take one, but every one of them's in double digits now. And then joining today on the orders list, we are expecting a potential order on a Damiak versus the United States, which is the amicus brief that both of your organizations were kind enough to throw in on and got. Kostas, I think you got NRA and FPC in on yours.
Not FPC, but NRA, CRPA, Minnesota Gun Owners Caucus, and one or two others. Citizens Committee. Unfortunately, we're not getting good news because I didn't see any, barring a surprise, I didn't see any requests for a response.
Right.
So it looks like
I'm a little worried about that too. Hannah, you got together with the Right to Bear Association and Palmetto State Armory and got an amicus brief in on this.
We're thrilled to make that happen. We're all located in South Carolina, and there are a couple of really, really great organizations, and just I don't know. Bill, you've played a role in introducing that and help, and we really
I am
appreciate
my job is to be a Second Amendment Cupid, and we have an orders list out and just be able to go out there and well, I could tell right now by looking at the orders list, we don't have a grant today, do we?
I guess not.
And no Duncan Lamont.
And probably, let me check a Damiak.
Please, no Adamiak. Just don't give me
A Damiak was denied.
Oh, Jesus.
Useless. This court is just so frustrating. You know why? You know why this one makes me extra mad? I know cert's always a long shot. Sure. I didn't have any illusions about it, but they set it for conference before the amicus deadline. Like it was like it's like they didn't even
want anything to do with it, right?
Yeah, they didn't even care. Like at least you should at least keep up the appearance that you're gonna like listen to what everyone has to say. So we filed early. You guys had to file yours a little early just to make sure it at least got read, and I don't think anyone even read them at this point. It's disgraceful what this court has done with, we get cert grants on the most technical nonsense that affects like 5 people. And someone like a Damiak has to now sit in a jail cell and hope for a pardon, which I guess now is his only way out.
It really is the only way out at this point now, isn't it?
Outrageous. It's just so disgraceful. Shame on this court. Shame on this court. Like, I mean, we care about, like, obviously they should, the assault weapons issue, the magazine issue are critically important. Someone's literally sitting in prison right now who should not be there on the most ridiculous facts ever. It's outrageous.
And like we've talked about before too, there are people who have pushed the envelope. There are, as I like to call, shitbirds out there that they play with fire and they get burned. But Kate Damiak ain't one of those. Yeah. Kate Damiak's a good kid, was serving the country. By all accounts, was a highly decorated sailor, probably had an amazing naval career in front of him. No criminal history whatsoever. And this kid could rot in prison for 20 years now.
a long,
Say that again, Hannah.
a long shot that the Supreme Court took it, but do it with dignity of demanding from the Department of Justice. I mean, it was under the Biden administration. You've got a new Department of Justice in there. Make them take a position on this.
Yeah. I would have
I
liked
agree
to
with
at
you.
least
It's a
seen
shame
the
on them.
court. I echo Kostas's sentiments. I would have liked to seen the court at least make the other side respond.
They
Yeah.
didn't, they didn't do the bare minimum to take this case seriously.
No, they didn't. Okay, for those of you who are just joining in, all 517 of you glutton for punishments, thank you very much for being here. Guess what we have today on the menu? We have a big nothing burger as it relates to the 5 platform ban cases that we have been closely following, but we do have some really bad news, not totally unexpected bad news, but the matter of a Damiac versus United States Tate Damiac's case has been already turned down by the United States Supreme Court after just one conference. They never even bothered to make the United States reply to it. Again, I want to commend all of Damiac's attorneys, and I really want to commend both of your guys' organizations for putting together a couple of fantastic amicus briefs and forming some really, really cool partnerships. Kostas, you mentioned the folks out at the Minnesota Gun Owners Caucus. I don't know if any of them are watching, but let's give them a big shout out. They had one hell of a weekend. They were absolutely on the grindstone all weekend.
What are you talking about? They failed to get us our 8th Circuit split. They were supposed to let that pass. They had one job out there. No, I'm
I
kidding.
know. We are, like, the 3 of us are very sickly kind of rooting for it. I got to go out to Minnesota next week, so I'm glad that I'm not having to go out there.
No, I'm not rooting for it unless the 3rd Circuit lets us down. Then I would throw on my orange Moms Demand Action t-shirt and I'm flying out there to fight for guns.
We'll be out in the state capitol next year screaming for it.
Yeah.
So, and the good news though is that if you can call it good news in that whole perverse incentive sort of way, likelihood is they will get it next year, which means by then we'll have a 3rd Circuit ruling.
Mm-hmm.
And the litigation scene could look very, very different. So either we'll have some action from the Supreme Court, probably. We'll certainly have our circuit split. One assumes the 3rd will have ruled by then. And then, there's always Minnesota.
There's always Minnesota. Well, guys, look at this. This is our conference schedule moving forward until the end of the term. So we're stuck with each other for a while. We got a conference again coming this Thursday, which means we're back again on Monday. Now, are we going to actually be back? Are they going to? Is it Monday Memorial Day?
Yeah, I'm guessing it'll be on Tuesday, not Monday. There will be a conference, but the orders list will probably be posted Tuesday. Yeah.
Well, we may be doing a WGL AM on Tuesday. I will be in beautiful Minneapolis, St. Paul out there. So I'll get to do a road show again. So, but all right, listen, we're going to move to our morning scramble. For those of you who are tuning in a little late, 1, thank you very much. Number 2, we don't have any news on any of the 5 platform bans that we've been closely following. We do have bad news on the matter of a Damiac versus the United States. Just want to get you guys up to date on some stuff going on with new petitions, and a lot of them a lot of activity coming out of the state of New York. This is one. It's kind of a goofy petition. Kostas, I'm going to have you take a look at it because this is actually brought in New York by an attorney in California, civil rights firm. I did some looking into it. I want you to take a look at it. We'll have a private conversation. Corbett v. Hochul. Interesting issue. Here it is. Whether footnote 9 of Bruin creates a presumption of constitutionality for shall issue licensing regimes firearm training mandate that relieves the government of its burden to justify that requirement under Bruin's historical traditional test. So this is something Hannah Hill and I have geeked out on probably more than any one topic, and we do a geek it out together. But we have talked about Bruin footnote 9 a lot, and I don't know if this petition has a snowball's chance in hell of actually making it there. But I want to ask both of you, what needs to be done to truly bring Bruin footnote 9 back into the context in which I believe it was intended to be authored?
You need a Supreme Court that's willing to do its job. I don't know.
Oh, then we're in trouble then.
What he said.
I mean, this is the issue we keep running into. Like, it's not that these are like tricky cases where the other side's making good arguments. No, like we have way better arguments and we keep losing. Like it's because they won't police the circuits. You know, other than, yes, they granted Wolford, which I'm grateful for. Thank God for that amicus brief from the federal government. But like at this point, they really need to be more active in policing these circuits. And I don't know why they're so scared to use summary reversals. You don't need to make everything a giant cert grant with arguments. Just summarily reverse these idiots a little bit more, you know, like not idiots. That's the wrong word to use for the lower courts. The lower courts, I don't even blame them. If you're anti-gun, the Supreme Court isn't reversing you.
You're not worried about the big boys sitting on top of you. They're going to bite you for doing something.
Yeah,
right?
like why would you? They're doing the smart thing, I guess. You know, since they hate the Second Amendment. So at this point, you need a Supreme Court willing to be more active in policing these circuits. Otherwise, Bruin means nothing. You know, because what good is the test if they're not going to enforce it? You know. I'm sorry, Adamiak. I think Adamiak's denial put me in a very foul mood.
No, that's fine. Listen, hey, if we do this thing in a foul mood, we're going to be in a foul mood. It is what it is. It's fine, Kostas. My level of frustration is growing significantly. Hannah, we cut you off. Go ahead.
Oh, yes. So basically, what you've got to have happen is cases chipping away at that footnote and everything that the lower courts are trying to do with it. Trouble is, the lower courts are letting you drive a Mack truck through it. Right? They're upholding everything through that loophole. And that's obviously not what the Supreme Court intended. But again, we keep coming back to the fact we can't get them to take the low-hanging fruit so far, which is a gun ban. And so, I mean, what you're going to have with the permit to purchase schemes that you have some on the books, some longstanding ones like in Michigan. You have other states joining them. And I see that as sort of the sequel to the gun ban, which eventually is going to go away. So you've got the permits to purchase like in Colorado and Washington State and everything else. Well, you know what's difficult to challenge about that is that Bruin footnote 9 appears to bless it, depending on how you look at it. So you bring a challenge. Will the Supreme Court take it?
Yeah. Well, see, this is my concern, and this is a good, Hannah, you brought up a really good point. So let's go into our time machine 12 months, 24 months in the future and say that we've actually gotten a ruling out of the United States Supreme Court that strikes down platform bans. Okay. Do we honestly think that some of these deep blue states are just going to bend over and take it? Absolutely not. They're going to come up with a way to try to circumvent that ruling. And the way I see them trying to do it is through pre-purchasing licensing, where they're going to be like, okay, well, you want a license for a handgun? That's $200. But you want to get a license for a semi-automatic rifle? That's going to be $2,500 or whatever it is. And we're going to have a 3-month training course that's only available to 12 people a year and things like that. But, as long as you complete all of those requirements, it's an objective criteria. It obviously is constitutional still. And that's the game they're going to play.
And if they're smart, they're not going to make it a $250 fee. They're going to make it a whole bunch of $20 fees. They're going because again, the one word in that footnote is abusive. Yeah. So if no single step can be said to be abusive, well, what's so bad about filling out a form and paying $20? Yeah. Then you've got the death by 1,000 paper cuts.
Yeah. Well, listen, real quick, for those of you tuning in, we don't have any, we got a big nothing burger, big helping of nothing burgers again on our 5 platform ban cases. Adamiak versus United States, unfortunately, has been rejected. A couple of other cases coming out of New York. We finally got a response brief in NSSF v. James. I haven't had a chance to go through it. That's probably one of the projects this week. We also finally got a reply brief in Johnson versus New York. As you can see, there's a lot of stuff coming out of New York right now. This is Johnson was busted for possessing a concealed carry firearm in New York without the proper permitting. His argument is I would have never been able to make it through the good moral clause standard, and therefore that's why I didn't apply. And so what we have is a person who's arguing that, hey, I'm being convicted under a statute that was actually later found to be unconstitutional by Bruin. Interesting issue. It's well briefed by Johnson's side. I have not had a chance to take a look at Letitia James' brief, but interesting issues. Don't know we can't get a platform ban taken. I don't know how we're going to get any of this other stuff taken. So
we'll have to see.
All right. Let's talk about rules, and more rules. And by the way, if you guys notice right there, the guy right above the first L in rules, that's John Crump. He's actually the named plaintiff in one of those. I think Ryan Pfluger is tucked in behind Todd Blanche's shoulder there. This, Hannah, you guys have both had a chance to go through most, if not all, of the rules. Hannah, let me ask you first. What are the couple rules that really jump out at you as yeah, this is awesome. And are there any rules that jump out at you as, well, I like where they're going partially with this, but I'm concerned that it's not enough or they're going the wrong direction? What do you got to say about that?
Pretty tickled about the engaged in the business rule. It appears to me that they've repealed as much of that as the Bipartisan Safer Communities Act will allow them. Now, the real question is what they do in the lower courts. Is that enough to moot out the challenges? Is it not enough? If it's not to moot out the challenges, I've got to take another look at those cases. I mean, it's not the ATF you're suing at that point necessarily, or at least not the ATF rule you're basing your lawsuit on. So was pretty tickled to see them pull it back as much as an executive agency can. And of course, the pistol price rule, they didn't get a Supreme Court. Unless I'm getting my rules mixed up, they didn't get a Mock versus Garland. They didn't get a Supreme Court ruling on that. They didn't wait for one to repeal the rule and moot out those cases. So I'm pretty glad to see that. The couple that I'm concerned about, obviously, is the gun registry up in West Virginia, the ATF Form 4473 registry. I don't think putting parameters on it is nearly enough. It's certainly better than, indefinite records retention. But 20 or 30 years from the time the ATF receives the records, that doesn't necessarily mean 20 or 30-year-old records. That's 20 or 30 years from the time the ATF receives the record when the FFL goes out of business. That's a lot of records. And I think the ATF, I understand the strategy of basically trying to put parameters in place that law enforcement's not going to challenge. Trouble is, the ability to trace a firearm is only so good because it's not only going to catch the good actors. The bad actors aren't going to, go through a box store. They're not going to buy it in a deep blue state that has, universal gun registration. So I think that the need for law enforcement to be able to trace all guns for 50 years or however long they want it to be is not as strong as they want it to be, and that they're putting more emphasis on law enforcement's desires than they are the rights of the citizens without them.
Kostas, do you have any rules that you've been through that you are thrilled with? Any rules you've been through that you think are a good start, but there's more work to be done?
I share the sentiments for the records retention concerns. Unfortunately, I don't know how much they're going to be willing to change that. But we just saw this past weekend, New Jersey sent out subpoenas to FFLs about Glock owners, Glock sales rather. And that's the sort of abuse that can happen when dealers retain these records for years and years. So there's a massive concern there. Sorry, I'm getting an echo on the mic. I'm not sure if you guys are hearing that or just
had a
me.
couple audio issues this morning.
Yeah,
but that's all right.
And but good stuff. There's a ton of great stuff in there. The interstate travel one, for example, is hugely important because FOPA's travel provisions have been abused for so long. Especially by places like New York and New Jersey. There's a lot of stuff in there that is excellent for people that already have it pretty good on gun rights,
Right. Yeah. There's a lot of rules that if you're behind enemy lines like Kostas and I, you're like, that's really cool if you live in Arkansas.
Yeah. I mean,
yeah.
Yeah, I know. So life continues to get better for them. NFA stuff will be much easier. Non-over-the-counter sales sounds awesome. It's great to live in the United States. But for the rest of
we should try it sometime.
Yeah, I know. But stuff like the interstate travel stuff, there are a couple things in there even for us, on our free trial edition of the Second Amendment.
Free trial edition. I love it.
So yeah, there's some good stuff in there. But overall, the ATF is Rob Leiter and Rob Scott are doing a great job on these rules. But there are a few things, that could be better. I did watch.
I had a conversation about the one about biological sex, and I thought that was interesting. And I did a video on it, and then I decided not to put it out because when I was just editing it, I just didn't like. I don't know. I didn't like my tone in it, I guess. So I decided I was going to do a do-over. But then Kostas and I had a conversation that really got me to pause, which is we do have some states. I'm sure my state's one of them. I think Kostas is. Hannah's, yours is not. That will give people an option of putting an X down under gender.
or they'll write like their driver's license will say non-binary or something.
Yeah, can be
I-
non-binary. Right.
Rob Leiter did an interview that I watched with Stephen Gutowski this past weekend.
Oh, yeah.
so-
Did they talk
and
about
he-
that?
Yes, and his opinion is no, this isn't going to block anyone from sales, and he did imply or state, I forget which, that ATF is going to be putting out guidance to dealers basically alongside this rule to say like, hey,
All
don't deny people because of this, just have them put their biological sex. But it still causes confusion. It could still, some dealers might be nervous to submit a background check where it doesn't match up, so they'll have to be pretty clear about this.
Yeah, and if there's ever a shift in political winds, one would question, would they get more leery of it when all of a sudden you got an ATF that's just busting ass again because about every little clerical error and inconsistency, right? This current ATF isn't doing it that way, but the previous version of them, and we can always go back to that version again. Is that going to be an issue? It's an interesting issue that I thought I understood. Now that I've scratched the surface a little bit more, I want to do some more thinking, because even though I think we don't necessarily see the world the same way as those that support the trans cause do, and that's fine. We're Americans. We can all agree to disagree. I think we can all agree that nobody should be disarmed merely because they've made a choice to identify as a different gender. We agree?
Yeah, and a lot of people,
for everybody.
A lot of people on our side don't like. Whenever I post about this, I inevitably get comments from people who normally agree with me, going, "Well, they're mentally ill." Okay, the problem with that is, even if that's what you think, Gavin Newsom will probably think a lot of you are mentally ill.
Yeah.
So there's all sorts of standards. So the standard for mental illness in federal law is that you are either involuntarily committed or you are adjudged to be mentally defective. Being trans doesn't fall under one of those, so you are not mentally ill. And we should be very careful about expanding that standard because it could be used against us.
Oh, yeah, because someday conservatism becomes a form of mental illness in the state of California.
Yeah, exactly.
But on the other hand, the federal government needs to have a basis of reality from which they operate. So this is a good gesture to move the needle back in that direction. To the extent that it causes problems for people who insist on not operating in reality, the problem you have there is that you shouldn't have to ask the federal government for permission at all. The issue here is that you shouldn't have the regulation in the first place. Not that the federal government is acting from a standard of reality in relation to the fields you have on the form.
The problem with that, Hannah, I mean, I agree historically, like that's what there was no standard like this in the history and tradition of the Second Amendment. But operating from reality also means that we have to accept that we have a cowardly Supreme Court that's never, ever, ever, ever going to rule against the 4473 or background checks. In fact, their historical tradition test had a giant footnote talking about how background checks are great, even though they never existed in history. So that's like that's the other problem. Like, I agree with you, but like this isn't going anywhere.
I know, but that's not the ATF's problem to fix.
That's true. That's true.
So I applaud them for this. It is a gesture.
Going on here, guys. I like this.
Sorry?
This is a good discussion. I like this.
I'm just in a bad mood today ever since
you want to be salty? You want me to throw up some
what's funny is I knew it was
your comments and you can shred on them for a few minutes too.
I knew the Adamiac denial was coming because they didn't request a response, and yet it still like put me in a bad mood. Yeah.
It stinks. It really does, because this kid is absolutely getting hosed. Absolutely getting hosed. So everybody, listen, for those of you watching, we got almost 500 of you online right now. Listen, contact your local congressperson. Tell them to get Tate Adamiac a freaking pardon, for God's sake.
I mean, we know they're looking at it. I think Robert Cicada at his hearing last week, he mentioned that they're taking a look at it, whatever that means. I hope that's serious and that they're actually going to do something.
I will tell you this. If you were a Republican who was really thinking about a run for the White House in a couple of years, hypothetically, you're the governor of Florida, current vice president, current secretary of state, somebody who might be on the short list there. I would start getting really vocal about the Tate Adamiac case. I would get really, really vocal about it, because if there is a pardon, you will be attributed to it, right, wrong, or indifferent. You will be mildly attributed to it, which will make you very well liked amongst the Second Amendment community, which might be an important voter block to have. Just throwing that out there.
I mean, just tell Trump it's for the gold paint at the new ballroom. And
Yeah,
tell him to sign it.
exactly. All right,
He
listen.
won't even read it, so it's fine.
We're going to talk about Rocky Mountain High. This is something we all kind of, I think, take a little personal joy in because we all know the current acting director of the Second Amendment Division, Mr. Barry Arrington. There are 2 lawsuits that got dropped. The United States versus Denver over their assault weapon ban and I believe their magazine ban, and then United States versus Colorado, which is over the magazine ban. And I do want to share with you some of the language that's being. This is your United States Department of Justice writing this. The term assault weapon is not a technical term used in the firearms industry. Rather, as Justice Thomas has aptly noted, assault weapon is a rhetorically charged political term developed by anti-gun publicists. That's your DOJ. Kostas and Hannah, questions for you here. I love the challenge. I love what they're doing, but is the 10th Circuit the right venue to be picking this fight?
Until there's a state in the 8th Circuit with something to sue, or the 5th, or like the 10th is of the anti-gun circuits. The 10th is probably one of the better ones. Like we get rulings like Ortega out of them. I'd probably guess they're going to rule against us on an assault weapons ban, but you gotta shoot your shot, right? Like what are we doing here?
You miss 100% of the shots you don't take.
So you got to try. Yeah,
that's as I calculate it. Now this is using the very unscientific method of which president appointed that justice to the bench, but it looks like there's a 7-3 liberal advantage there. Anna, you were for many years a Colorado gal. Spent a lot of time. There's a lot of time litigating in the 10th Circuit. What's your impression of it?
Well, I had a personality conflict with the entire state and all of its courts, but I assume that's not
that's
your
why you're
question.
back home in South Carolina now. Much happier girl too, I've noticed.
So we actually just won at the 10th Circuit on the Colorado ghost gun case. The district court said, no, we're gonna call this a commercial sales regulation and skip the Bruin analysis entirely. The 10th Circuit panel said, nope, can't do that. Go back and try again. That was a huge win. And the good thing about the 10th Circuit is that it's not the 9th Circuit in that it en bancs everything. It is very rare actually to get en banc review. So the numbers, not only do the numbers say we have a chance, but the court's rules and precedent also say we have a chance that if we get a good ruling there, that it'll stand. So after the 8th Circuit, the 10th Circuit is the last place to go for a possible circuit split. So yeah, this was also unfinished business on Barry's part.
Yeah, there's a little. Well, you see it coming from Colorado and Denver too. There's a little personal animus there between the two sides. So this is going to be a good fight to watch.
Not many people know this, but Barry was a state representative in Colorado.
Yes,
and he has fought the leftist communists in that state in one way or another for many, many years. And I know he's taking a lot of personal joy, as are we, in watching this one go down.
What did you guys think about the Second Amendment Division amending the complaint in United States First District of Columbia and adding the suppressor ban in there?
That was very cool.
Wasn't that cool? Like, oh, by the way, this is also unconstitutional.
I know that's another thing that like our friends in the red states don't care about because they already have, like, they're worried about, can I get a suppressor without registration? Meanwhile, I'm over here in California, like, can I please do an NFA application? Please, please. Like,
you can't even get them.
Pay the tax.
The folks in Illinois
got rid of. Let me just have a suppressor.
Yeah, Illinois, you can't get them either.
Yeah.
Outright flat ban. And I told everyone in Washington, I figured Washington State was going to pass a ban this year. So I was like beating on that drum, telling everyone to stock up. Some suppressor companies probably owe me some commission because I got a lot of people to buy them. But yeah, I just think that this is fantastic. The nice thing is it's not a lot of extra lifting there because basically the analysis that Barry was using, I should say the Second Amendment Division, it's not just Barry, but the Second Amendment Division, the analysis being used on the assault weapon is similar to the exact same legal analysis they're using with the suppressors as well.
So we were pretty tickled to see, a while back, the DOJ, I think it was in a case in the Fifth Circuit, one of the NFA challenges, that the DOJ switched their position and said, you know what, we're gonna concede that, suppressors are arms under the Second Amendment and deserve.
Peterson case.
Yeah, okay, I didn't remember which one it was. And so to see them doubling down on that and just throwing it into the gun ban lawsuit, it's a very efficient way to do it. because that case is already moving. Now you've got Barry's division over it. Let's see how far he can take it. You know, it'd be fantastic to get some constitutional protection nationwide for suppressors.
Oh, guys,
would be-
we got some breaking news. I'm sorry. The Second Circuit struck down the vampire rule on a final judgment in Christian v. James, which is an FPC and Second Amendment Foundation case. I probably should have read my own org
guys.
first.
Congratulations to FPC.
Congratulations. That's awesome.
That is awesome.
I
That's
haven't read it yet,
Second
but we'll be
Circuit, too.
doing a thread later. So some good news today. I mean, granted, if they couldn't strike that down, we're not winning anything.
Was that a full en banc panel ruling, or is that a
No, but there was a Biden judge in the majority. I don't know if there was a dissent too, but I hope not. But yeah.
Well, we'll check that out. Congratulations to SAF. Congratulations to FPC. Fine piece of work. You know, I should also point out, you know, I got representatives here from NAGR and Second Amendment Foundation with us every morning. If somebody from FPC, if somebody from GOA, if somebody from the NRA wants to join us one morning, we'd love to have you. We're Washington gun law. We don't play favorites around here, so we are happy to host as many of our fine Second Amendment.
Hey, what the hell does that mean? You don't play favorites?
Huh?
What does that mean? SAF and NAGR have been here for weeks and weeks with you, and you're going to just say, "Oh, I don't play favorites with GOA." Screw them.
Well, listen, I invite everybody. It just I happen to like you
I'm
two
just-
so much that you know. I mean, it's a personal
I
preference.
mean, look, if Bill was going to pick a favorite, I think we all know who it would be.
Probably you, because you're not as you don't get as irritated at stuff.
I will tell you that Hannah has a very sweet side to her. She's a very endearing person, so I might pick her. But then again, if you know Dudley, you also know that you got to take Dudley in small doses, right? Dudley's like a recreational drug, right? He's really good as long as you're doing it in small doses. All right, listen, here's a couple things I do want to talk about. Let's remind, here we go. We got the GVRs. These are cases that we're waiting to just get another do-over. Let's remember that we got two cases that we're still waiting rulings on. Kostas, Hannah, do you guys got any prediction when we might get a ruling out of either one of these cases?
I'm basically breathing into a paper bag before every single opinion day. So
Okay.
I think we'll get Wolford anytime now, I think.
Okay, all right. Let's remember that we got 3 cannabis cases kicking around: Harris, Sam, and Nyandaro. We got several young adult cases: Paris, the Glass case, West Virginia Citizens Defense League, McCoy, and Pecan. I think I'm pronouncing that. And then let us also add to it the case of Morvey Kipke. That one is also hanging out there. And this may be a big deal. This is Morvey Kipke is out of Maryland. Kostas, is Maryland in the Second Circuit?
Maryland is
Fourth.
No.
I think it's the fourth because Snope was in the Snope came out of the Fourth Circuit. So yeah, Maryland.
Map up on my wall.
Yeah.
So Morvey, oh, that's right. Hannah does. Yeah, Hannah, that's right. There's a little circuit map right there. So Morvey Kipke deals with Maryland's vampire rule. So I'm assuming that case is being held because they're just going to kick it back after they're done with.
Yeah, Maryland just filed that just in case the Supreme Court shocks everyone and we lose Wolford. So that's why they filed it. But I think they know, like they just said they were just the lawyers there were just covering their bases in case something surprising happened. But yeah.
We got a new category. They're called the mayfly cases. For those of you who are entomologists, you will know that the average life expectancy of a mayfly is somewhere between 12 and 24 hours. Learned that in college, Hannah. This is all of the cases that, using Kostas's criteria, which has proven to be amazingly accurate, if you are scheduled for a conference after the other side has waived their reply brief and the court is okay with that, you are a dead man walking. All of these cases, I imagine if you look in it for any of these on the orders list today, you will see that they have, in fact, been rejected. Interesting, the one at the bottom there, United States v. Mitchell. These are all 922 G1 like challenges. Martin v. Florida, obviously, is the one coming out of Florida equivalent state law. But you'll see down there, United States v. Mitchell, parties are in inverse order. That is, yet again, another case coming out of the Fifth Circuit where the Fifth Circuit said, no, as applied to Mitchell, 922 G1 is unconstitutional. Another cannabis case.
And that one is not denied. I just checked.
Not denied.
Not denied. It's not on the list.
Okay.
Beabrun or whatever was denied.
Oberon? Yeah.
Yeah.
Yeah. What about Tongay? I think that's how you.
Tongay's denied.
Yeah.
Martin's denied. Oh, well, hold on. Martin v. Florida. Yeah, that one's denied.
Yep.
Cruz v. United States denied. Yeah.
Yep.
So it looks like all of them except Mitchell again were denied. Yeah.
Okay. All right. Well, and if that's a cannabis case, they may very well be just hanging on to that one and waiting for Hamani to come out then.
Yeah.
Okay.
They've been very predictable when it comes to GVRs, though. It's going to be interesting to see what they actually do.
I'm really curious about the 18 to 20 cases. I don't know, you know, because I guess they could GVR them after Hamani, but that means they better be pretty clear on the who questions in Hamani and not as narrow. That would mean they'd have to not be as narrow as they normally like to be. And actually,
what I can't understand is that the 18 to 20-year-olds are coming under, is that 922B or something like that? It's entirely different section. And you got all these you got all of these cannabis cases. And you got a lot of these 922G1 cases. And I mean, the slaughterhouse has continued. I tried to count last night. I think there is almost 100 922G1 petitions that have been rejected by the Supreme Court now.
Yeah, I mean, and that's what's bizarre, because if they are holding the 18 to 20 cases because they're going to expand on the standard of, you know, they're going to explain who can be disarmed, you'd think the G1 cases would be much closer than just 18 to 20-year-olds who have no criminal record. They're just 18 to 20. So I don't know what's going on. Maybe we're wrong and it's not related to Hamani and they're doing something else. I don't know. Maybe they're planning to grant cert to one. But if they were trying to consider which one to grant cert to, why aren't they being relisted every week like the hardware cases? You know,
that's the thing. Because every one of those cases, I don't think a single one of those 18 to 20-year-olds, these cases right here on the right side of this slide here, I think that the last time any one of them conference was like January.
I thought it was November. Yeah. Maybe there was a straggler.
There were some that conferenced all the way back in November, never to be heard from again. And then a couple of the later stragglers that came in had a quick conference in early 2026, and then they
also put into the freezer.
Yeah.
Maybe the Supreme Court's hoping that if they pretend they don't exist, they'll go away.
The Supreme Court has no reservations about just breaking our hearts. Don't worry about that.
That's true. Well, but they've also got to decide, the DOJ's in play as well. That makes it a little bit trickier for them.
I don't think the DOJ, I mean, the DOJ's, you know, the best we've ever had, but I don't think they're going to go to the mat over 18 to 20. I could be wrong on that, you know, but, who knows?
I mean,
well, listen, for those who all tuned in today, all 494 of you that are still live right now, thank you very much. Just to give you a quick recap, right away, we got the orders list. We looked. Our 5 platform ban cases are nowhere to be found, which means not a thumbs up, not a thumbs down. It also means that they're probably going back on to conference on Thursday. And we're going to do this all over again. The bad news, the one piece of real bad news, not completely unexpected, but still terrible news, is that Adamiak versus the United States, that petition has been rejected. The United States was never even required to file a reply brief. And so the only way we're going to get Mr. Damiak out of prison at the current time is through a pardon. So I'm asking everyone out there to start contacting your local congresspeople and let them know that this is something we insist upon. Closing thoughts, Hannah, you got anything you want to say? We'll be back probably next week. It probably looks like it's going to be Tuesday, but any closing thoughts you want to say?
I just think there's a lot to be encouraged about right now, notwithstanding the Supreme Court. There's a lot of good stuff happening in the litigation world. The ATF is doing a lot of good stuff. It's just it's a fun time if you could just get over the suspense the Supreme Court's keeping us in.
Excellent words. Kostas, I'll give you the last words.
We need a pardon for Adamiak now. That's what we need. You know, that's where I'm focused, and I hope that if anyone at the administration happens to be watching this, which I doubt, but actually, no, I shouldn't undersell Bill like that. I'm sure.
Well, no, that's okay. But you know, it is the work day, so you know, if you are at DOJ or something like that, and you're watching, thank you very much. But get back to work, man. What's going on?
Pardon Adamiak and then get back to work.
Pardon
Adamiak and then take the week off. We'll allow that.
Week off. Back next week. You know, and we'll get ready to go. Okay, listen. We will announce when we're going to, I got to take a look and see when the actual orders list is scheduled to come out next week. We will schedule it. I will actually already be in Minneapolis, so I'll probably be doing it from a Holiday Inn in beautiful St. Paul, Minnesota. Anyways, I want to thank both of you. And again, I want to commend both of you and your organizations for getting in gear so quickly, getting those amicus briefs in on a Damiac, forming the partnerships that you guys formed with there. They were both fantastic briefs. I wish it would have turned out a lot different. It certainly wasn't due to a lack of effort on your guys' part. So congratulations. I know that the Damiac family is going to be grateful for that too. I just want to see that kid get out of prison sometime real soon here. All right, that is it for Washington Gun Law AM on May 18th. A momentous day here for Washington State residents. May 18th is a huge day here if you live in Washington State. We all remember where we were at 8:32 in the morning on May 18th, 1980, because that's when Mount St. Helens blew up. And when I say blew up, it actually blew up. 1,300 feet of the mountain disappeared in a nanosecond. So I can still remember I was laying on the living room floor reading comics. This is how old it was, not long ago, reading the comic strip. And there was this huge boom and the house shook. And I remember my mom saying, like, what the hell was that? And I was like, I don't know. And then the way our house looked south down the Puget Sound there. And within about a minute or two, you could see this mushroom cloud rising up in the sky. And that was Mount St. Helens letting her rip. So
That's crazy.
It was. All right. Listen, guys, thanks so much for being here. I'll see you in a week, 8 days, depending on when we get to do conference. For all of you who tuned in, thank you very much. I appreciate it. You're all gluttons for punishment as well. You guys have a wonderful work week. Catch you next. Yeah, man, that a Damiac